What my role is I'm a solicitor and I specialise in body corporate law, which is quite different from a property sense in terms of development law. Development is who builds your buildings. Body corporate law is dealing with strata and community title once the building is built. And that's the area that I practice in, and that's what we do. One of the things that we're going to talk about is managing debt in a body corporate. We're really going to only focus on one aspect of debt, which is contributions and outstanding contributions. And the reason why we're going to talk about is we've had a situation in the property market really over the last 4 or 5 years where we've had a lot of lot owners who have struggled to actually pay their body corporate levies. And a lot of the committees have spoken to me about the fact that, yes, but we know Mrs. Smith just can't afford to pay. And as a consequence, committees have allowed those levy periods to roll over, and some of the body corporates have found themselves with an individual lot owner who might have a reasonable amount of debt owing to the body corporate. And obviously the higher the debt is, the harder that situation is to deal with for a body corporate. So, what we're going to look at today, no, skip that bit. Importance of levy, body corporate role, body corporate debt, I'm going to wait there when I'm reading that. Non-payment of contributions, strategies, protections, and the body corporate for the wave and Westpac. The body corporate for the wave is a particular body corporate that we're going to talk about because they've actually had quite a tough time regarding an individual lot owner within their building, a gentleman and a lady called Dr. and Mrs. Prims. I can tell you all about it because obviously it's a matter of court record, and we were the solicitors who acted for the body corporate in that matter. As a result of what the body corporate for the wave has been through, it's actually provided substantial protections for other bodies corporate. So although there have been the test case, it has provided lots of benefits for other bodies corporate, and we're going to talk about those protections and benefits as well. This looks like quite a complicated flowchart, and I don't expect you to go through or actually to be able to read it in some detail. With this presentation, what Capital is going to do is they either have it up on their website, or if they have your email address, they're quite happy to email it. So you can look at the processes involved. This is actually a flowchart of the processes that we go through in terms of collecting an outstanding contribution, so a levy from individual lot owner. And it is it looks like a complicated process. When we break it down to specifics, it's actually quite simple, and the processes that we go through. But just to give you an understanding of that's the sort of situation that actually the body corporate for the wave and Dr. and Mrs. Prince went through. Next. Why do we talk about a body corporate and the importance of collecting those contributions? Because a body corporate is there to do one sole purpose, and that is manage the community and manage those community assets which are your common property. The body corporate is not running a business. Your body corporate is not there to charge interest, to provide services, to make a profit. It's not a business. Your body corporate is not a lending institution. It's not a bank or some other financial provider in terms of providing money to individuals or terms and lengths of terms in payments to individuals, such as payment plans regarding the payment of their contributions. The body corporate's sole function is improvements, financial management, and repair and maintenance of common property. We don't repair lot property. We focus and deal with those common property assets. And we can't do that unless we have money. There are no real other sources of revenue for a body corporate other than you as individual lot owners and raising those contributions. So when one individual doesn't pay their contributions, it substantially impacts upon everyone else's obligations. It places them as a disadvantage. It is discriminatory. It is unfair. And that's why the process must be managed carefully and early to make sure debts don't become high. In terms of dealing with that, the legal responsibilities which are placed on committee members who are basically our directors of the body corporate, and they're our volunteer committee members. Who are committee members here today? Not many? Which is good. It's a big role that a volunteer takes on, and there are substantial responsibilities, legal and otherwise, that attach to that role as being part of a committee. The decision to institute legal proceedings against an individual lot owner who may be suffering from financial hardship but who hasn't paid their contributions is a decision that weighs heavily on committee members. And we know that because we talk to a lot of committees and we talk to your body corporate managers as well. The decision to start legal proceedings, though, is a committee meeting decision, and it is not an extraordinary general meeting or an annual general meeting decision. It doesn't go to all lot owners, it falls on those directors of your body corporate to make that decision. In terms of looking at our legal obligations, there are very few legal obligations on the body corporate regarding giving notice of what that contribution is to a lot owner, because the legislation places a high standard on the individual lot owner, and there are lots of mechanisms in place to give notice to that lot owner, so they're aware of the depth of the law.
Sorry.
You've got to. Can you go back?
Sorry.
Do I need to press? Thanks, Jill. There we go.
Sorry.
One of the things that we have to do, and the first thing that we as a committee on behalf of a body corporate need to get right, is the setting of the budgets. We have to set the admin and sinking fund budgets, and obviously that involves insurance regarding the building as well. Getting those budgets right is extremely important for the overall management of our building. Why? If we don't get the budgets right, and that's where we greatly rely upon our assistance of our body corporate managers to help us do that. We're not going to have enough money to repair and maintain and deal with our aspects and the financial responsibilities that we have throughout the building. Two, we just got to hold a valid annual general meeting. It is not difficult to hold an annual general meeting. That's why we have our body corporate managers who we rely upon to provide advice, and we make sure the votes are counted and those resolutions are passed at the general meeting, and they resolve to issue the contributions. The body corporate's last legal obligation is to make sure that it sends a notice of contributions, that's your tax invoice, to each lot owner at least 30 days before the debt is due and owing. Must give 30 days notice. So as a lot owner, I've seen the budget committee meeting minutes, I've seen the notice and agenda for the annual general meeting, I've seen the voting paper for the general meeting and the day the general meeting was held, I've received the minutes of the general meeting, I then received my notice of contribution that says 30 days and then it's due and payable. How much notice do you think that is? What sort of time frame do you think that takes? It's quite a reasonable period of time. We average it out to about 3 months. From that committee meeting, going up to the holding of the annual general meeting, and then another 30 days for that notice. So your individual lot owners within your building have 3 to 4 months notice of what is the contributions for the next year. That is not a difficult concept for individual lot owners to understand. And often when we have phone calls, and what our first step in the process is sending out a letter of demand, so we have a lot of phone calls with individual lot owners who do suffer from financial hardship, who do believe that it's very important to pay their mortgage and their rates first, but don't pay their body corporate levies. And they're the type of discussions that we have with them, so lot owners understand the processes involved. They're the legal obligations. There is one more that sits behind that, which is right at the beginning when the lot owner first buys in, the Form 8. The Form 8 is the notice of address for service. That's when I, as a lot owner, or my solicitors acting on behalf of me, fill in my Form 8, send it to Capital Body Corporate Manager, and they transcribe the information correctly and accurately so that the address to service on the roll is correct. It is a lot owner's obligation to make sure that address is correct. You can't change address over the telephone, it's not appropriate. As Ashley stated in the beginning, on the website there are significant forms and information which Capital put out One of those is a change of address for the role. You fill it in, send it in, address is updated. So there is no excuse for people not receiving that information. In terms of the legal obligation, is there a legal obligation on the body corporate to telephone the lot owner and remind them to pay their levies? No. Is there a legal obligation on the body corporate to send reminder letters, which Capital does, and they have a process where they implement a levy arrears process to follow up lot owners nicely with reminder letters? Do you think there's a legal obligation to do that? No. No. There's a practical reason as to why we do it, because we want to manage those processes carefully, and we as a body corporate, through our body corporate management company, and Capital has a very tight system, where we want to be reasonable in all the steps we take to make sure that we're contacting the lot owner and recovering or reminding them to pay those debts prior to instituting legal proceedings. So it's more of an ethical, moral responsibility where we consider those to be reasonable steps taken, but there's not a legal obligation. 4 months' notice has already been given to the lot owner before they receive their notice of contribution. No one should be unaware that there are levies and that levies are required to maintain the building. What makes up a body corporate debt? The levies. This is what goes on the ledger statement. The levies. Penalty interest. Penalty interest can only be charged if an appropriate resolution has been passed previously by the body corporate at a general meeting. Most of your bodies corporate probably have those resolutions in place because penalty interest or discounts are used as a substantial deterrent or benefit in terms of encouraging lot owners to pay their levies. Okay? There are some bodies corporate that choose to put that motion on every annual general meeting notice to remind lot owners on a continual basis that it is 2.5 penalty interest when it's applied on a simple interest basis per annum. That is 30% per annum. It is the highest interest rate that anyone in Australia is capable of charging. Australian Taxation Office can't charge that rate. No credit card is entitled to charge that rate. No financial institution. Only bodies corporate as a result of the legislation. Why? Because it's so important that lot owners pay their levies. The Court of Appeal has said 30% interest is not unreasonable because of the substantial disadvantage other lot owners are put to if you as an individual don't pay your levies. It's one of the protections that came out of the body corporate for WAVE. It just confirmed what we all knew. Costs. Costs are important. Often, and over the last 4 or 5 years, when lawyers have read this word, any cost, recovery cost, they automatically did, or in Queensland for some reason and New South Wales, a lot of the law firms in terms of dealing with body corporate debt would look at it like standard debt collection. And that's, oh, well, recovery cost is magistrates court scale costs, or it's a part of your fees. That's not what it says. It says any costs reasonably incurred. That means your administrators, Capital Body Corporate Management, and the costs that they incur on behalf of your body corporate in chasing a lot owner for their debt is a reasonably incurred recovery cost. So it includes those administration costs. It includes legal costs of instituting proceedings. It includes costs of cost assessment if the lot owner defends the proceedings and demands an assessment of all the itemised costs. Okay? It is expansive and wide because of the importance of paying the levies. Steps for the body corporate to take. We've already covered this very quickly. Ensure the address of the lot owner is correct. That's what Capital does on behalf of your body's corporate. They make sure that that information is correct, but it's not an investigative service. We don't hire private investigators to do those things. It's not appropriate. A lot owner has a responsibility to get that information right on the Form 8, If it's not right and Capital receive return to sender letters, then we do investigate behind that. But we're not going to spend substantial body corporate money on satisfying a duty that a lot owner can simply correct themselves. Attempt to contact the lot owner directly. That's if there's a phone call or the reminder letters. If we don't have a phone number, it's a bit hard. If we don't have an email address, it's also a bit hard. Keeping your address up to date is extremely important. Internal recovery processes. That's your reminder letters and your letters of demand that Capital does for you through their arrears team. Document steps taken. Every step that's taken by Capital through their arrears team, they document it. And it's great because when they document it, we get a nice little package for when the committee passes the resolution to engage OMB Solicitors, and then we act immediately for recovery of that debt. We don't have to go behind the systems to see the steps that are taken because we can rely upon and trust the information provided by your body corporate managers. Okay. Before we talk about payment plans, we spoke just before about the committees and the responsibility of committees to pass a resolution. When we talk about the institution of legal proceedings, it is an important step which is taken by body corporate. The purpose of passing the resolution is the committee is authorising the engagement of solicitors to physically file a court document in the magistrate's court where we then personally serve that individual lot owner. And personal service is extremely important. One, it's a legal requirement, but also that's how we get the attention of the individual lot owner who has failed to pay their contributions. All recovery costs are only recoverable on the basis that they're reasonably incurred. The reason why you have the steps in place by Capital and resolutions passed by your committee is that you have already exhausted attempts to locate that lot owner, and the steps that you're taking are reasonable. And that's why those costs are recoverable, and that's why they're added to the ledger statement. There's still a debt paid by you as the body corporate first, but ultimately the responsibility is that individual lot owner.
Excuse me, Juliette. Because of the noise, do you want to just use the microphone for a minute?
Are you okay?
No. Can you all hear?
Yeah,
You can. Okay. All right.
Payment plans. Payment plans we deal with here because it's important, because one, Capital gets those requests for payment plans, and then you as committee members are asked to say, consider, oh, well, do we accept the payment plan or not? Because it's actually your decision. We talk about payment plans from a legal perspective as well, because as lawyers, once we issue the letter of demand and actually start the statement of claim process when people are served, we often get a request from an individual lot owner stating financial hardship and wanting a payment plan. Is there a legal obligation on a body corporate to accept a payment plan? No. No. Can a body corporate have a no tolerance policy on lot owners for accepting payment plans? Yes. Consistency, non-discrimination, so don't discriminate against other lot owners. Explain what your policy is, set it out in writing and notify all lot owners. There are numerous buildings on the Gold Coast that have no tolerance policies. I'll give you a specific example. A very large building, Chevron Renaissance, which is about 700 lots, has a no tolerance policy regarding payment plans. The lot owner's already given 4 months notice. The debt is due and owing by that date. If it's not paid, it's not paid. And then appropriate procedures are put in place to recover that debt. All the lot owners are very aware of that at Chevron Renaissance. The reason why that decision was made is because 4 years ago, the body corporate at Chevron Renaissance had substantial debts. Not hundreds of thousands, over $1 million. It's a lot of lot owners. So using that multiplying factor of 700 lot owners, it's expensive to run Chevron Renaissance. It is expensive to run a duplex. Got less lot owners to share it between. So it's the same reasoning and philosophies that apply. So there is no legal obligation on a body corporate committee to accept a payment plan. Is there a legal obligation on a body corporate to act reasonably? Yes. Yes. So that's always our overriding consideration. A lot owner has missed 2 levy periods As a result of those 2 levy periods, let's say the body corporate debt is $2,500. At $2,500, we have an individual lot owner who's struggling to pay those levies because she's already rolled over. The interest rate's already charging at 30%. As a result of that, the debt is increasing. She writes to the body corporate, your 2 capital body corporate managers, and says, I'd like to pay the debt off at $50 a week. $50 a week for a $2,500 debt is not acceptable. Why? Because it will never catch up the debt. There will never be, it will continually roll into the next levy period. A payment plan can only reasonably be accepted by a body corporate if all the debts are cleared before the next levy period. That there is an undertaking from the lot owner that the next levies, as and when they fall due, will be paid. There is a specific, there should be conditions that are placed upon all payment plans that lot owners are very clear that they understand, if I don't meet these conditions and I don't do what I said I've agreed to do, then I will fall straight back into debt collection. Okay. That's how payment plans can work successfully. Who has the responsibility to pay for the administration of the payment plan? Because you have to administer it. That lot owner. Okay. All of those charges should go back to the individual lot owner. It puts a lot of pressure though on your body corporate management company to provide that extra service to manage those payment plans. If you have a lot owner who is continually behind in their arrears, should you accept a payment plan? Probably not. People have to understand the significance of paying their levies on time. Payment plans should be used in more exceptional circumstances.
Can I just ask, we're talking about levies, does that include special levies?
Yes. Yeah. Actually, that's a very good question. I'll give you a specific example. Contributions are levies, but we only talk about the recovery of contributions. Let's take a standard format plan, break it down in simple English. A standard format plan is individual townhouses with no touching walls. So they're all standalone little houses. What defines a standard format plan is, think of a square, which is the block of land, and survey pegs at each corner. Okay? The survey pegs indicate where the lot goes. That makes a standard format plan. Okay? Different to a high-rise building where we go up, and we call that a building format plan. Okay? Learning some of my lawyers forget the definitions of those sometimes. Within that block where the survey pegs are is the home. Is that home the responsibility of the body corporate to pay or the individual lot owner? Individual lot owner. That's exactly right. Why? Because it's lot property. Okay? So often in standard format plans there's not a lot of legal obligations for the body corporate because there's not a lot of common property. Roads, driveways, all those sorts of things. Regarding that home though, we've got 15 houses, 5 are painted, 5 are in a state of disrepair, and 5 look terrible. As a body corporate, we want to fix that. So we might update our bylaws, we might pass a resolution, and we say the body corporate's going to take responsibility on behalf of the lot owners, and we're going to engage a contractor, being a painting contractor, and we're going to paint all of those lots to make it look great. All the lot owners go, oh, that sounds good. We pass the resolution at the general meeting. We then have to issue an individual repair agreement to each of those lot owners because that's the contractual obligation. And then we issue a tax invoice for that proportion for that lot owner for the painting of their house. That tax invoice is not a contribution. It's not a levy. It's a separate tax invoice. No penalty interest can attach to that tax invoice. Okay, it cannot go on the ledger statement, put it on a separate ledger statement. So only contributions attach penalty interest and reasonably recovery costs. If a lot owner, let's say the cost was $1,500 and under the repair agreement the individual lot owner didn't pay that tax invoice, okay, then the body corporate may sue in the tribunal to recover that amount. Is it entitled to all its reasonably incurred recovery costs? No, it's not a contribution. At standard debt recovery, separate. That makes sense? Quite actually a complicated legal area, but it's important to understand. Whenever we receive a ledger statement from Capital Body Corporate Management, we always review them. The reason we review them is to make sure there's not water, electricity, gas, or other extra charges that might be on the ledger statement that aren't contributions. That due diligence is always done. I forgot what I was talking about. Levies, payment plans, that's right. So only levies, only penalty interest and recovery costs. Oh, 10 minutes or 5 minutes?
10.
That's lucky. Payment plans, be very clear, be very specific. Capital, through their levy arrears team, will not send you just the one-line email that comes in from the lot owner that says, I want to pay $50 per week. Capital will always review it, and if it comes from us, we review it beforehand. We will only send you or recommend a payment plan if we think it's appropriate. Next. If all else fails, what next? If the second levy is unpaid, so a levy is unpaid and you've rolled into the second levy period, institute legal proceedings. Okay? You need to have very good reasons as a committee on behalf of a body corporate if you allow a debt to roll from one levy period to another levy period to another levy period. In the legislation, there is a legal obligation that levies must be recovered within 2 years and 2 months. It's the only piece of legislation that actually states a time frame for recovering debts. The statute of limitations that applies is still 6 years, but it's prompting committees to have a mandatory obligation to make sure that they don't go into debt. Okay. Committee resolution engaging OMB Solicitors, send final letter of demand if debt outstandings. As I said, this is not a restricted issue for the committee, so the committee is entitled to pass the resolution. Regarding that resolution, the committee at the time when they pass it don't know that the type of lot owner they're dealing with. Because it could be anyone. We can't see in the future.
Does that 2 years mean that if they haven't paid, when do you actually put proceedings in for actually selling up the lot?
No, we talk about that. The proceeding for selling up a lot, so a seize and sale of warrant, which is what we call it, that actually is just the same. It just comes from those basic legal proceedings. So a magistrate's court claim and statement of claim is filed, that's served on an individual lot owner. That lot owner may not defend those proceedings. Then you apply for judgment and obtain a piece of paper, just one A4 piece of paper that has the judgment debt on it. That judgment debt then becomes enforceable on behalf of a body corporate. Part of the enforcement proceedings may be a seizure and sale of the lot, where we get a writ enforcement warrant. We have to pay $3,000 to the bailiff as a retainer. The bailiff will then do a bailiff auction. It is very unlikely and unusual for bodies corporate to seize and sell a lot for the purpose of selling it. We typically only do that on behalf of bodies corporate in circumstances where there's no mortgagee, and typically your properties on the Gold Coast, you have mortgagees. It's more unusual not to find those circumstances. If there's no mortgagee involved, it usually is part of a trust company or a trust or a company where we go through different enforcement mechanisms. So it's still part of the same court proceedings, but it's not a step that's often taken. To give you a more specific example, Magnetic Island International Resort, which is up at Townsville, a lot of those properties were bought by investors without mortgages behind them. The property is valued anywhere between 50, 60, maybe 80 when it's running well. So if there's people behind with their debt, we usually do seize them and we sell those. At different circumstances. Okay. When a committee passes the resolution to institute proceedings, the committee does not expect that it is going to be fighting against a Dr. and Mrs. Prince, which is what happened to the body corporate for the way. Dr. and Mrs. Prince not only defended the court proceedings, they appealed 5 times. You cannot restrain and stop an individual lot owner from defending or appealing. You can make applications for security costs and do as much as you can to prevent that. But occasionally those circumstances arise where you are dealing with a particularly difficult lot owner. If that is the case, and the legal fees involved are going to exceed the committee's spending limit, then you must go to a general meeting. And not only legislatively must, morally, ethically, obligations to other lot owners. You tell them what are happening. And that's where we come in and we attend a lot of those general meetings. Not a lot, we have very few in those circumstances. And those circumstances are very few. They're rare, they're the exception. Most legal proceedings for the recovery of outstanding contributions, your legal fees are between $3,000 and $4,000 to obtain judgment, and then the mortgagee pays. Next. When you start proceedings, you do it when the debt's relatively low. Why? Because that's when people are able to pay it. You be proactive, you be consistent. The higher the debt, the more likely the lot owner will defend it, and then you'll be in for more costs and it's more pain for everybody. Next screen. What protections are there? You have your costs reasonably incurred, the debt attaches to the lot, we can talk about that in a moment, mortgagee in possession, and policy considerations. The policy considerations are your body corporate policies. Does this body corporate have a zero tolerance policy or not? Next screen. Let's talk about Westpac Banking Corporation for 5 minutes. The body corporate for the Way had an extremely difficult time regarding Dr. and Mrs. Prince. We were required in court to call this lot owner Dr. Prince because he had a doctorate of jurisprudence. That meant he was a lawyer. Well, at least that's what he told the court, and then the judge made us call him Dr. Prince throughout the proceedings. Self-represented, took the matter all the way through. Magistrates court proceedings, when we finished up, the judgment against Dr. Prince and his wife was $150,000. The only reason we stopped it at $150,000 was that was the jurisdiction of the magistrates court. We actually couldn't get any higher without transferring up to the district court. Why was it so high? Because he fought and fought. Applications for security costs, applications for discovery, subpoenas on the body corporate. He put that body corporate through hell. 6 of us had to sit in the witness stand and give evidence. 3 of my lawyers, myself, a gentleman called Ben Strangman, and a solicitor called Candice McLean. All 3 of us being cross-examined by a self-represented litigant, as well as my secretary, my treasurer, and my body corporate manager from SSKB. 5 days the hearing went for nothing. Judgment against the lot owner, $150,000. He can't pay that. He then appeals to the district court. He then appeals to the full district court. He then appeals to the Supreme Court. He then appeals to the full Supreme Court. While that is all happening, we get special leave to bankruptcy. Finally, we bankrupt him, stops the court proceedings. Sometimes there is an individual lot owner who will fight for the principle, and as a body corporate, when they pass that resolution, you don't know that. You don't know that that's going to be the outcome in the end. Westpac Banking Corporation, though, knew that he was a vexatious litigant. That's why they chose and made a decision not to step in as mortgagee in possession. Once judgment was obtained for $150,000, the body corporate notified the mortgagee. As a result of notifying the mortgagee said, oh, you know, our debt actually far exceeds the value of the lot. We're sitting back, we're not doing anything. In addition to that, he's written to us to say he'll sue us if we step in for possession. So the bank allowed the body corporate and basically forced the body corporate to do their job for them. At the end of the court proceedings, once bankruptcy was finally achieved, Westpac Banking Corporation then sued the body corporate. Yeah, I know the height of them. They sued the body corporate for the purpose of saying, this is not a body corporate debt. We're a mortgagee in possession. We're only responsible for contributions and interest, not the recovery costs, which of course were the main part of the debt by then. Westpac Banking Corporation put that application to the Supreme Court, they lost, took it to the Court of Appeal, lost again. So the body corporate was finally successful, but significant pain for a body corporate to go through to provide the rest of the body's corporate with significant legal opinion on what is a body corporate debt, that the debt attaches with the lot, and that it is the mortgagee's responsibility when they take possession.